Hi, this is Ed Weinberg, and this is the CTRE Investors Meetup. We do our meetup typically twice a month on the first and third Thursday, although being that it's the end of the year, we're going to miss a couple, and we'll go over that later. We're going to start out with some introductions here. So let me see. Mark, you're on the line. Tell us what you do. Well, I'll introduce myself first. My name is Ed Weinberg. I am a real estate investor. I've been investing for a long time, and I am also a real estate agent at Keller Williams. And I can handle listing houses and finding houses for buyers anywhere in the state of Connecticut. Mark, why don't you tell us who you are, what you do, where you do it, and, if you've got another business there, you can mention that too.
Absolutely. Thank you. Mark Simmons, actually for the past 25 years, I've been a train conductor going up and down the Northeast Corridor. Just launched a photography business, something that I'm very excited about, but got a little keen eye for real estate investing in multifamily homes, so that's where I am at this point. And that brings me to the meetup.
Okay, great. So we're also on the line. We have Venoal Fountain, and he is an attorney with Hirsch, Levy, and now Fountain. You're a new partner there. Right?
Yes, I am, and thank you for the introduction. My name, I'll just say it again, is Venoal Fountain. I am now a recent partner with Hirsch, Levy, and Fountain. I would like to just add as a little footnote to that is that I've actually been with the firm for quite some time. I worked for the founding partner prior to joining the firm back in the early 2000s, and then took a little hiatus from the legal field and did some IT work. And then once I decided that I was going to pursue law school and become an attorney immediately after finishing the bar exam and passing that and getting sworn in, the now partner, attorney Sharon Levy, gave me an offer to come back to the firm just as an associate that has now evolved into me being a partner.
Okay, that's great. So tell me, maybe you can tell me, what is an eviction and why do I want one? Or need one?
Well, so an eviction is basically a termination of the tenancy by the landlord to a person who is using and occupying a premises owned by that landlord for the purposes of renting. And when you pursue an eviction, you're basically, as a landlord, saying you want to terminate the tenancy agreement, whether it's written or verbal, and you are now looking to take legal possession of the premises, which, once you engage upon a landlord-tenant relationship and relinquish keys to your tenant, you lose that right of legal possession even though you still own the property.
All right. So are there specific reasons that I would use to legally to as reasons for an eviction?
Sure. I mean, Connecticut law enumerates a number of different grounds or reasons for eviction. One of the most common that my office sees, I'd say about 50% of the time, is a non-payment eviction, a tenant just not paying the rent or falling behind for any reason. Another common eviction is something which is called lapse of time, and that's just simply a desire of the landlord to terminate the tenancy agreement for no necessarily fault of the tenant, but perhaps the landlord simply doesn't want to be a landlord anymore, or for other reasons. There's also a few other reasons that pertain to squatters, such as people occupying the premises just by virtue of breaking into the premises. This happens a lot with properties that are on the market as a result of foreclosure and have been sitting for a while. Every now and then people want to, basically take it upon themselves and move in. Well, there's enumerated laws as it relates to eviction for property owners and or landlords to deal with those types of situations. And then there's a few others as well. I mean, it would be here forever if I got into all of them, but there are some specific reasons that are enumerated in statute for the purposes of an eviction. And then, of course, you have your full gamut of reasons that become a violation of the lease agreement, which brings in, other procedural things you need to do prior to the notice to quit if that is the case.
Okay. I guess my next question is, can you outline? First of all, can I do it myself, or do I need an attorney to do an eviction in Connecticut?
That's a very good question. I'm going to answer that basically on a sort of a twofold thing. To answer your question on face value, yes, any pro se party can do an eviction on their own if they are, in fact, the owner of the property. Where it becomes a little bit more complicated in Connecticut is if you are a company or an LLC, you do have to retain the services of an attorney because, most people may or may not aware that as a company or an LLC or any type of business that is not a person simply doing it as a DBA, which stands for doing business as, there's a requirement for an attorney because that business or that LLC is in fact its own separate entity, and because it's not an actual that entity is not an actual person, that entity does need to be represented by a licensed Connecticut attorney.
All right. Can you run through what a typical timeline would be? Let's say that today I decided that I was going to I'm going to evict someone by myself, and I want this to happen as quickly as possible. So what would I do on day one? What would I do on day X, all the way up to the eviction?
Well, that's a really good question, and it's a pretty loaded one. Most evictions, and I have to say, anything that I say here obviously is not legal advice because every situation needs to be treated as a case-by-case basis pertaining to the specific fact pattern or issue that is at hand. However, generally speaking, evictions can start in Connecticut with a notice to quit if it's a material violation of the lease, such as a non-payment. But one of the things that's always important, and one of the things that I always do, particularly with my client base, is I always want to review the lease because the lease may have some language which prohibits the landlord from serving a notice to quit if there's some material default such as non-payment. One of the things that I always tell my clients is if you do in fact have something like that in your lease, you want to take it out because it's really not required in Connecticut for material breaches of the lease, again, such as non-payment. But one of the things you would do is start with the notice to quit, generally, if the lease does not have that information. And then you can move on after the notice to quit expires if the tenant has not vacated the premises, because that really is the intent and the purpose of the notice to quit, in addition to terminating the tenancy. Then you would move on with what's called the writ, and that is simply a preparation of your summons and complaint, which both those documents do need to be served by a state marshal. The Connecticut does allow the notice to quit to be served by what's called an indifferent person, but I never recommend that. I mean, it is something that can be done, but if that notice to quit is ever challenged and you had an indifferent person serve it, you're going to be faced with having to defend the service of that notice to quit. So, again, just to jump back procedurally, after the writ summons and complaint is served upon the tenants, that document is in fact filed with the court, and from that point, you're either going to end up with a court date, just depending on how the pleadings go. Pleadings are basically, how the tenant responds to the issue at hand, and how the landlord then responds back to that. And then after the pleadings are, what the law deems as closed, you may end up with a court date. After the court date, or once you get to the court date, that is really the tell-all as to what's going to happen with your case. In Connecticut, if you move the case along as quickly as Connecticut law allows, you can have a court date within 6 to 8 weeks from the service of your notice to quit, perhaps even sooner. Generally speaking, my office has a court date within that time frame if there's no extenuating circumstances such as another attorney on the opposing side, et cetera, et cetera.
Okay.
Right.
So once we go to court, I guess that depending on what happens in court, different timelines happen. What are the choices of what would happen when we went to court?
Well, that's a really good question as well. I mean, one of the things that I think is important for any landlord to realize is that when you bring a summary process action, which is basically an eviction action in Connecticut, you are requesting from the court permission to take legal possession of your premises. So what happens when you go to court is what is before the court at that point in time is the issue as to whether or not you as the landlord have a legal ground to take that possession. Generally in Connecticut, every matter that goes before the court does or is subject to some form of mediation. I know specifically in housing court there is mediation that does take place, and during that mediation there's an attempt to resolve the issue of possession, whether that be a non-payment situation, whether that be a violation of the lease, whatever. And it's really up to the landlord as well as the tenant at that point if they're going to come to some sort of agreement as it relates to the issue of possession, meaning is the landlord going to take possession at some definitive time, which is specified by a court order, or is the landlord going to allow the tenant to stay, which happens very often, requiring the tenant to become compliant with the lease. And that, again, is usually a non-payment situation, but not always the case. I mean, it can be issues of having a pet. It can be issues of smoking in the premises. It can be issues sometimes with, federally subsidized funding, a tenant recertifying and complying with, certain procedural and or rules and regulations of the premises in which the tenants live. So it really is something that you can, if you are creative, make contingent upon possession. So in other words, a tenant may be able to stay in possession of the premises if the landlord allows, and that court-ordered agreement is an enforceable binding document, which is going to make the tenant as well as the landlord comply.
Okay, so we're going to come to an agreement, and it could be that they pay some back rent?
Correct. It can be that... Oh, go ahead. I'm sorry.
Yeah, it could be that we raise the rent?
Well, here's the thing. Generally speaking, when you bring a notice to quit, that's a very good question. I always discourage any raising of the rent at that point in time, because what happens when you serve a notice to quit is you terminate the tenancy from a legal standpoint. So once you serve a notice to quit, you let your tenant know that you as a landlord no longer want to rent to them. So once you get into court, if you're seeking to raise the rent, and by the way, just as a side note, it's not even called rent once you bring the action in court. At that point in time, the landlord is simply allowing the tenant to use and occupy the premises. So the concept of rent becomes null and void after you serve the notice to quit, and everything going forward is a discussion of use and occupancy, which in and of itself is the rent, but it's the legal meaning of what and how the rent is being taken once the action is started.
So if they pay me, if the court orders them to pay me money and they pay me money, I give them a receipt for use and occupancy, not a receipt for rent.
That is correct. And that's very important because, many times a landlord may go ahead and serve a notice to quit. And this goes back to your initial question, can a person do it on their own? The short answer is absolutely, but it's not recommended because it's not recommended if you're not familiar with all the nuances of how Connecticut law operates. I mean, there may be some landlords who have, been leasing properties for, 20 plus years. In fact, I have some clients that have been leasing properties for 20 plus years, and they understand conceptually what they can and can't do, and they are, they certainly can do some of their own evictions. Sometimes I do some of them, sometimes I do not, and they understand, the do's and don'ts of Connecticut law. But if you are a new landlord or you're not certain of the do's and don'ts, my recommendation is always to contact. Obviously, you can call me. It's what our law firm specializes in, but feel free to call an attorney of your choice and make sure they do have some knowledge of this area of the law, because these little nuances, while minor, can actually, ruin your entire case, such as something as simple as taking money after you serve the notice to quit and you give the tenant a receipt for rent. That's one of many.
Okay, so I'd have to start over again?
Absolutely. And you have to be careful about starting all over again, because there's certain rules that are in place that talks about a notice to quit being unambiguous, and if you have multiple notices that have multiple quit dates, now you're coming afoul of that. So there's certain things you need to do to address that as well, and it's always, again, on a case-by-case basis, and it depends on what has transpired from the service of your first notice to your subsequent notice, et cetera, et cetera.
All right. Now, let's say that I have a tenant and he didn't pay me this month. What date? The rent is due on the last day of the previous month, typically. Is that right?
Well, Connecticut law states, many people think, let's just say if the rent is due on the 1st. We'll go with that concept because that's usually what happens with most lease agreements. The rent is due on the 1st. So what happens on the first day of the month, if the tenant does not pay the rent, under Connecticut law, that tenant does have a 9-day grace period to pay the rent. Generally, this only applies with residential, not necessarily with commercial. And if the tenant does not pay, within that 9-day grace period that's allowed by law, that now puts you on the 10th day of the month. So as of the 11th day, assuming there's not a written lease that speaks to the contrary, the landlord does have a right to proceed with an eviction action.
Okay, great. Well, great. That's not good, but that's good that we know the answer. All right. So next question. You mentioned earlier that you sometimes have these issues with vacant buildings where somebody breaks in. So if somebody breaks in, I never made I don't have a verbal agreement with them. I don't have a written agreement with them. Let's say that, and you can tell me whether it's different if it's a property owned by an individual or a property owned by a bank. What do I do? Can I just send over a big guy with a bent nose to tell him to leave? Or, what do I have to do to get them out legally?
Well, that's, and all of these questions are very good questions that really become more and more contingent upon the specific facts, because you may have a vacant property that's sitting. You may have a property that, could have been owned by an owner who was foreclosed upon. So a lot of what needs to happen is if there's an individual in a property that was either deemed vacant or you're not sure if it's vacant or what the status is, you really need to know, what's going on with the person that's in the property. Because you said maybe it could be foreclosure or maybe it's not foreclosure. It's really important to have specific information, because that information, believe it or not, will be extremely telling as to how you proceed. For instance, if it is a foreclosure and there's someone living there and you're not sure if it's the owner or not, perhaps it is the former owner. Well, there's certain things that you need to make sure of as it relates to the foreclosure laws in Connecticut, to make sure that certain things under the statute were complied with as it relates to a foreclosure action and before you commence an eviction on such a situation. When it comes down to, a squatter, and you absolutely know that it's a squatter, well, you can start right with the notice to quit, So there's certain things that you really need to have specific information, and whenever I have a client that has a problem with something like that, my thing is to have an interview and really probe them so we know how to proceed and make sure that every I is dotted and T is crossed, because the worst thing that could happen happen is you end up, with your court date and you're in court, and then you realize that there was something that hasn't been complied with as relates to the situation and the status of the tenancy or the occupant before you serve the notice to quit.
Okay, so maybe let me ask some specific questions. Let's say that I have an apartment, it's empty. I go there to take a look at it or to show it to some prospective tenant, and I see that there's someone living there who I don't know. The old people, the people who were there left. I've never seen these people in my life. Can I just call the police and say, hey, these people are in there, they don't belong there, kick them out?
The answer to that question is no. I would always proceed with caution because here again, you have to find out if you cannot find who your leasees were or are, and you have no idea.
Well, no, this is my apartment. I own it, and the old tenants moved out, and some people moved in who I don't know. So I know that they're not the old tenants because I know the old tenants.
So you know definitively that the old tenants have moved out. Well, the next question becomes: did the old tenants provide the access to those people?
Oh. Okay, so let's say the old
because if they did, yes,
the old tenants didn't provide access, and they just moved. This is really simple. The old tenants moved out. A week later, there's somebody new in there. The old tenants had nothing to do with it. You had nothing to do with it. They broke in, and they just broke in and then started living there.
Well, I would say, it really depends on the timing and how long that they've actually been there. It's always good to start with the police to see if that works out. But 9 times out of 10, if they've established, they being the person that's living there, has established some sort of residency, and if you want to eliminate yourself from liability, then yes, you should go through the eviction process. But, I mean, if you're talking, timing is everything and facts are everything. No person has a right to just trespass because there becomes an issue as to whether or not those people are actually trespassing or are they residents. So here again, it puts you back to the factual basis as to what you can do. If they're trespassers, then the police have a right to kick them out of there. But if they're not trespassers and they have in fact established a residency at this place, then yes, you're going through an eviction process.
All right. Now let's take the situation, and this is something that I see more and more, where banks are selling properties, and they're saying you can't even look at the property before you buy it because there's somebody living there, and you're going to have to we're going to sell it to you subject to somebody living in there who may or may not be the owner. What do I have to do if I buy the house? There's someone living there. The bank knew they were there. The bank didn't kick them out or evict them. What are the questions that we should ask? And are we basically going to have to evict them, or does the foreclosure terminate their lease?
You would definitely have to answer your question. You would definitely have to evict them. I mean, I have this situation on a number of occasions where sometimes in a foreclosure action there's this order from the court, which is called an order of ejectment. I'm not going to speak to that very much because it's not something that I deal with often, but most of the time with a foreclosure action, for whatever reason, that order of ejectment is either not enforced, or perhaps it was enforced and maybe someone did squat in the premises between the time of enforcement and, a subsequent sale. So yes, you would have to go through the eviction process. There is an enumerated statute, within the eviction Connecticut General Statutes area that allows you to evict on a ground of, a person not having a right or privilege to be there. It is one of those enumerated statutes that allows you to go right to the notice to quit and start your eviction process.
Okay. Any questions you can think of that I should have asked but didn't?
Well, I think one of the telling questions that is when you start an eviction process, I think it's really important. This is what I'd like to say to those that are out there listening. It is really important to understand that an eviction process is not you kicking someone out of your place. And an eviction process, generally speaking, from my opinion, does not have to be a contentious issue between the landlord and the tenant. My recommendation is if you're having any issues with your tenant whatsoever, whether it's non-payment or other violations of your written lease agreement, you should address those issues head on and right away. Most specifically, non-payment. I mean, everyone goes through life challenges every now and then, and maybe dealing with some financial difficulties. It's not uncommon, particularly in today's economy and society. But if you're dealing with decent people who are leasing your premises, you can work with those people, and you don't need to work with them, outside of the court order. If you start an eviction process and you say to them, hey, listen, I understand you lost your job or you're going through a rough time or whatever the situation is, that's fine. We're going to start this eviction process. Hopefully by the time we get this case into court, which is at least going to be, about 3 to 4 weeks from the inception of the case, perhaps you'll be able to get a job or get some income, or your luck will change, or whatever the situation is, and we can stipulate by virtue of a court order that you're going to start paying on time, and then, by the way, you're going to pay me the money you owe me as well. And with that court order, it's an enforceable court order, whereas a tenant cannot be 1 day late or $1 short under Connecticut law. And if they are, the landlord reserves the right to go back to the court and let the court know there was a default in that agreement and continue with the eviction. So that's always a recommendation that I talk to my clients about, because it provides a layer of protection. Saying to someone, okay, I'll make a payment agreement out of court is not really going to help you, because if the tenant defaults, you're still calling, myself or another eviction attorney to go through the process. So, making an agreement outside of the court is not something that I typically recommend.
Okay, so let's say that the judge says it's time for them to go, and the date is here that they need to leave. Do I just walk in and say leave?
No, that's another good. So at the end of your case, if there's a default in the case, or if your case resolves by the tenant having to vacate the premises, there's one additional document which is called an execution. If you get an order for judgment on the day that you're in court, which could happen, the landlord can't just from that day go to the place and kick the tenant out. There's a 5-day period in which the court does have to advise the tenant that you have 5 days to leave. Judgment for possession has been entered against you, and during that period, the landlord is prohibited. And neither will the court sign that execution for the landlord to remove the tenant. Now, once the court signs it, which is after the expiration of those 5 days, then of course the landlord can take that document. The landlord still cannot do it himself, but give that document to a certified Connecticut state marshal for the county in which the property is located, and then proceed with the eviction with the state marshal. That's a very good thing, because that provides an extreme layer of protection for the landlord to avoid any accusations that may be said or alleged by virtue of the tenant from the landlord.
So is the
to the landlord, excuse me.
Okay, is the tenant responsible for taking all of his stuff out, or can I send in some guys to just pick up and move the stuff, or what? Well, how do we get all their stuff out of there?
No, what happens is once the court signs the execution, and this is something that is a bit out of my scope, but I can talk about it a little bit. Once the court signs the execution, that execution has to go to the state marshal. And then the state marshal basically takes over the eviction from that point, and everything becomes the discretion of the state marshal, because the state marshal is the I call it the on-site person who is looking at, the condition of the premises, what needs to be moved out, and many times, the state marshal goes ahead and coordinates the move with licensed movers, and those items or the items of the tenant are moved literally from the premises to the local city or town warehouse for the tenant to pick up, at their discretion. I don't know specifically how long each one of these towns holds the tenant's possession, but I think it's generally about 15 days. Otherwise, it's either auctioned or discarded, from what I believe. That I'm not, again, 100% sure of, a little bit out of my scope.
Okay.
Mm-hmm.
Mark, do you have any questions?
Well, you guys covered a lot. I did have a question here. If the how many months can a tenant miss paying before a landlord, let's just get into a lease, and the tenant has like a late fee? Now, if the tenant missed 2 months in a row, at that point, can a landlord step in and say, you know what, start the eviction process? Or is there a certain period of time you have to wait before a tenant miss paying the rent before you can actually start the paperwork for an eviction?
Whatever day the rent is due, that's a good question, but whatever day the rent is due, the landlord has the legal right to proceed with an eviction if the rent is not paid 9 days after the date rent is due. The landlord does not have to wait another month, does not need to wait 2 months. The only thing I will say is that with a non-payment situation, it always goes back to the lease. If it's silent in the lease, then what happens is that 9 days is applicable. I have read, and I can say this, I read multiple lease agreements, and I see more times than I would like to see, a default clause where the landlord is saying to the tenant, if you're late with your rent, I'm going to give you 15 days to become current. And you really don't need to do that because Connecticut law has a 9-day grace period built in. So if the lease agreement, gives a grace period, that grace period becomes, in addition to many times, what the Connecticut statutes have already allowed. So it's something that I always tell my clients, refrain from putting that in your lease agreements because you may find yourself at, the 25th day of the month before you're starting an eviction.
Okay. Anything else, Mark?
I'm also wondering, too, I know you talked about, I think, with a lapse of where, let me see, I wrote it down to be sure, lapse of time where a landlord for basically different reasons just decide, I don't want the tenant in the home anymore. At that point, if a landlord decides to do such, what are some of the things that a tenant can do if he's been paying his rent on time to actually fight against that?
To fight against a lapse of time eviction?
Yes.
To be frank with you, there's no defense to a lapse of time eviction. I shouldn't say that. There is defenses to a lapse of time eviction, but not from a general perspective. If a person is a protected class, they may have some valid defenses to a lapse of time eviction, but from a general, and there's a number of people that are considered protected classes. We'd be here for quite some time if I got into each individual one or each individual type of protected class. But a landlord has a right to say, I don't want to rent anymore. And that's what that law is there for.
Okay. Wow.
Many people don't know that, but that's the truth of the matter. When you're dealing with a lapse of time eviction, you just have to make sure that, and again, there's a number of things that you have to look at to ensure that a tenant is not a protected class, and as long as that tenant is not protected by virtue of the facts in the situation, then the landlord is cleared to move forward on a lapse of time eviction. Now, there are different levels of discretion that the court has with these types of evictions. So there's different discretionary measures that the court can take with a lapse of time versus a non-payment, because when we go to court, the court is a court of equity, and they want to make sure that things are being fair and equitable for both the landlord and the tenant. But, generally speaking, there's no defense to that type of eviction.
I have one more question real quick, if you don't mind. When a landlord decides to rent to a tenant, should he seek a lawyer in writing the actual lease, or that's something he or she could do on their own? You think they should do on their own?
I always recommend, because a lease agreement is a binding contract. It's a contract between you as the landlord, and it's a contract, with the tenant. So it is always my recommendation whenever a party signs a contract, particularly if they may not be familiar with the nuances, to seek legal counsel.
Okay.
All right. Well, and I just want to say, Ed, I thank you for the opportunity, and if anyone does have any other questions or concerns as it relates to their specific legal matter, I know we spoke very generally tonight, but as I said, this area of law has so many different nuances. I have to speak on a general perspective because I wouldn't want anyone to take what I'm saying and then try it on their own, and then all of a sudden they run into a hiccup. So every eviction is really on a case-by-case basis if it's not sort of a straightforward non-payment. And even those, if there's a number of different variables, can be, tricky.
Okay. So maybe you can give us your website and your telephone number if people want to get in touch with you, Venoal?
Sure. So my name is Attorney Venoal. I'll spell that. Venoal, Fountain, just like a water fountain. The name of my firm is Hirsch, Hirsch, Levy, Levy, and Fountain. We are located in Fairfield, Connecticut, right in the downtown area. Our address is 140 Post Road. We're on the 5th floor, and that's located in Fairfield, Connecticut, obviously 06824. My telephone number is 203-336-3144. I will repeat that, 203-336-3144. And also our website is www.hirschlevy, so that's HIRSCHLEVY.com. And, feel free to visit our website if you would like to have a discussion, as to your personal situation. We do provide some consultation, and we usually do that free of charge. So feel free to give us a call, and we can hopefully help you out with whatever landlord/eviction issue you may be having.
All right. Well, thank you for joining us, Venoal. And so a little bit of coming attractions. On 12/7, I'm going to have Attorney Kent Miller. He's going to be talking about the new CT landlord laws that took effect in October. And that we're going to skip the 11/16 because there's so much else happening this month, and we will most likely skip the second Thursday next month, which is 12/21, and then I guess that's going to move us out to the first of the year. So in January after that, we'll be meeting on the 4th. And I hope every week to see everybody there then. So you'll be able to see this, listen to this audio at the website ctreinvestors.com. We can also be found at the Facebook group CTRE Investors, and at the meetup group, which is also called CTRE Investors. We also have a YouTube channel, which is where all of the audio ends up. And the YouTube channel is CTRE Investors. Basically, everything is CTRE Investors. And thank you for joining us, everyone. You all have a nice night.
You as well. Thank you.
Thank you.